Okay, let's kick this off. Last week, we started to turn the corner. Last week, we turned the corner from dealing with vitiating factors into dealing with discharge. So I have spent quite a lot of time doing contract law. This is the final quarter. And so that last week we talked about how people get out of contracts by doing what they promised to do, which is kind of the most straightforward way of that happening in the first place anyway. Whereas this lecture is really going to be about when things start to go wrong, when sides don't do what they say they're going to do, and what's going to happen. It's about moving down this path towards ending a contract through breach. I'll turn that off. That's not. Oh, sorry. I'll turn this. Go away. Okay, so turn this volume down. Volume down. Down. Okay. And there's two sort of major areas of this. I'm going to do these two separate recordings. But when we're looking at breach, the fundamental thing to start with is that it is to do with one or both sides not living up to their side of the particular bargain. Oh, is that better when you guys actually got something on the screen? Ah, there we go. Much easier. And this idea of committing breach and not living up to what you promised to. What do we call the promises in a contract? What are they called? Terms. You've made a series of terms in an agreement, and there's two sort of broad umbrellas of ways that people can go about doing this breach. And I've got to talk about them because they're actually really kind of important. Again, these are a series of rules that you guys from this point forward can actually go through and think about in your day-to-day life and in your professional lives. Because breach of contract can really come about through people not doing stuff because they just don't do after the fact. So at a point in time's happened and they haven't done something. All right. But it can also come about ahead of performance where one side has demonstrated this unwillingness to actually do what they promised to do. Either an unwillingness or an inability. And so this area of law, it's been mapped out by the courts of ye olde England for a long time to make the system as efficient as possible. Because not just do we want people making a lot of contracts and ideally not breaking those contracts, but we want to have a system that reflects that, look, from time to time, people are going to break contracts. And we want to have a series of rules in place, not just for when people actually rock up on the day and break contracts, but also ahead of time. Because we want to have a system where there are practical solutions to things that can happen before the date of performance. Because if, in a lot of situations, if you wait until the date of performance, the results can be really messy. And most importantly for the courts of ye olde England, very inefficient. We don't want parties to rock up to a contract with a bunch of perishable goods, for example, rock up on the day, and all of those goods perish. We don't want a boat to go to a particular port ready to pick up some cargo to find out that the cargo isn't there. If we know about these things in advance, we want to have some mechanisms in place to try and give parties some options ahead of time. Because this real starting point here in contract law, it's a fundamental rule, is that contract law is what we say actionable per se. Now, some of you may have heard that before. You may have heard it in tort, for example. Does it sound familiar? Anybody here that's done torts A? No one has done torts at all? Okay. torts are, you talk about the torts involving trespass to the person. We say they're actionable per se. That means is that there's no requirement to prove damages. And the same thing applies in contract law. Breach of contract, this is a really important point. Breach of contract is strict in liability and actionable per se. So that you, if you don't do what you say you're going to do, it is utterly irrelevant that it is not your fault. From this point forward, tuck that one away in the back of your head. If somebody enters into a contract and then doesn't turn up to do what they say they're going to do, the fact that it's not their fault, the fact that their child was sick, the fact that they didn't get the goods from the supplier, the fact that they overslept through their life, doesn't matter. It doesn't matter. None of that matters in contract law. Contract law is about people coming together, promising to do things in an arrangement that the law is going to enforce. And when they don't do those things, the innocent party gets a right to sue. And they get a right to sue for at least nominal damages. Nominal damages, $100. Yes, your rights were infringed, now go away. You can always sue for a breach of contract. That's the starting point in contract law. It's a really important point. And so here, when we're thinking about the innocent party, the side that's not in breach, in practical terms though, it's not uncommon for both sides to have some aspect of breach. And they can both bring actions for this failure to perform. Okay, now a key thing to note though, when we're trying to determine what happens when a side breaches, you can always get damages. Damages is an award of dollars. It's an award by the court in order one side to pay the other side. Here, the breaching side to pay the innocent side a sum of money. That's damages. You can always get an award of damages where the other side has breached. And this is different, remember, and different and distinct from the rules I taught you guys last week involving things like the de minimis rule. The law does not concern itself with trifles. There, it's not considered to be a breach. Contract's essentially been performed. Okay, but if we can determine there's been a breach, doesn't matter what it is, we will always get at least nominal damages in court. So, when we're trying to determine how much that dollar awards us, that's the calculation of damages. We're going to do that at a later stage. We'll do that another week. Here, we're going to look at what's going to happen when one side is breached. Because as well as getting damages, one of the very important rights that the innocent party gets is, in some situations, they get a right to terminate the contract. In other words, the innocent party, at a point in time when the other side has breached, they can get a right to terminate. And it's all to do with the seriousness. The seriousness of breach is the thing that determines whether or not the innocent side either gets a right to terminate and seek damages or just a right to get damages. And we call the classification of these words conditions and warranties. Now, unfortunately, these are legal technical terms. From this point forward, what you thought those words meant in the lay sense, you have to displace that. If you're going to be lawyers, you are now replacing those two words with the legal technical meaning that I'm about to go over now. So if ever you've heard the word condition being used before, lay people, non-lawyers, use that expression to mean a term. And they say, there are a bunch of conditions in this contract. No. Us as lawyers go, there are a bunch of terms in this contract, some of which are conditions, some of which are not. Because a condition is an essential term in a contract. It's a term of a contract that if near strict compliance of its performance wasn't to be guaranteed, the parties would never have come together to form this contract in the first place. And this is to be contrasted with all of the other terms, which we call warranties. And again, the lay, non-lawyer term, expression, warranty, we mean that in terms of things like consumer guarantees. This has got a warranty for 4 years or 2 years. We go and we take it back, good remember, right? You have to replace that word in your head from this point forward. In contract law, a warranty is a minor term, the breach of which does not give the innocent party the right to terminate. So I'll go over those again. From this point forward, a contractual condition, that word, you hear the word in law, condition means a term of a contract, the breach of which will allow the innocent party to both terminate and get damages. And a contractual warranty is a minor term, the breach of which only gives rise to damages. This is an important distinction between those things. It's unfortunate that we use these words elsewhere in the English language, and from this point forward, you guys are going to be lawyers. When other lawyers use those words, that is what they mean. When lay people use those words, they will be meaning something else. You have to translate from this point forward. Now, there is a test for determining whether or not a term is going to be a condition as opposed to a warranty. And it comes from this Luna Park and Tramways case. This involved the tram company in Sydney negotiating with Luna Park, which was an amusement park in Sydney. Which is kind of strange because I associate both of those terms with Melbourne these days. I don't think Luna Park, I don't know if there is one in Sydney. They don't have much in the way of trams though, do they? They got both. Okay, cool. Anyway, it was to do with signage, a bit like we would have signage on buses these days. The idea is that, hey, we've put these advertisements for Luna Park onto these buses, and the court basically had to work out, because the way the contract was expressed was these signs are going to be on the trams for 8 hours every day. Sure, seems a pretty straightforward sort of a scenario. Sure, these trams are out there going around for 8 hours and our signs are on them. Doesn't sound too problematic. Well, trouble was, the way that trams work is that some of them will be working for a little bit and then some of them will break, and then some of them will come off for a bit and the driver will have lunch, and then another one will go back out. And so some of these things had signs on and some of them didn't in their network. And so what that sort of said was that, look, on average, these things are going to be out there for 8 hours each day. And the courts, courts in this situation are stuck with something of a dilemma. When they're interpreting this particular contract, they have to work out whether Luna Park had rocked up and said, no, we're going to terminate this contract, whether they'd actually done that lawfully or not. And so they talked about this test. They said that, look, when we are going to go into a contract, when anybody goes into a contract, it's all about whether we would never have gone into this contract if we weren't guaranteed near exact performance in regards to the term of that particular contract. And so how that sits often requires the courts to go through and examine. Would we have come together if we had not, or would an objective third party looking in have thinking, these parties wouldn't have come together and had this contract if that particular term wasn't guaranteed near exact performance. That is called the test of essentiality. And that's the test that the courts use for determining whether or not a particular term of a contract is an essential one, a major one that gives the right to terminate, or it's a warranty, a minor one. Associated Newspapers and Banks was a case involving a cartoonist And the cartoonist's contract, part of it was that we're going to pay you to do this this particular cartoon, and we were going to put it on a certain page, like page 3 of the newspaper. And then at some stage later on, the newspaper moved it somewhere else in the paper. What's the problem with that? As a cartoonist, well, even though it seems like a minor point, because you're still getting money as well, you as a cartoonist, if your cartoon is on page 3, and if people open up the newspaper, it's right there. If you've moved it to another section or further through the newspaper, that's fundamentally changing it. And the court said that, look, even though it seems like a minor issue because the guy was still getting paid money, actually that component of it wasn't minor at all. It was really, really important. And so that near exact performance in that situation was going to be a requirement. Okay, now, that's the easy bit. Well, it's not the easy bit, but it's the starting point. Oh, you're right. Got it. Sweet. We need to categorize them as one or the other. What's the problem with that? There are some types of terms that just don't fall into that category very well. This is actually quite a recent phenomenon in contract law. And so we call terms that sit in between conditions and warranties, we call those intermediate terms or innominate terms. And the reason why we do that is because a minor breach, they're going to be treated like a warranty, and a major breach, they're going to be treated like a condition. So in Hong Kong Fur Shipping, in Kawasaki Kaizen, there was a shipping company. There was a freight company, and there was a company which owned a boat, an old boat. Wasn't particularly seaworthy, and they made a charter for 24 months, and they took the boat from South Africa, I think it was, somewhere in South Africa, and they had to take it back to the UK. And the crew were useless, and the boat kept breaking down. They couldn't repair the engines. It was a really low quality vessel, and so as a result, it was off. They couldn't sail it for a decent length of time. They were trying to work it out, so it was months and months and months before they managed to get the thing out, and it kept breaking down. And so the courts there went and analysed that particular term. Was the 24-month requirement a condition that had to be adhered to strictly? And there they said, look, in this particular situation, this term that things have got to be done and ready for 24 months, it's really one of those ones where there's a question of degree. And the courts look at that, whether or not it was a minor breach, a couple of days, or whether it was a very large fraction of the entire contract itself. 10 months, for example, might be. And there they said that, look, a few months probably isn't going to be sufficient. Sure, you appreciate this. They're still going to get money. The other side's in breach of contract, but it's only a breach of a warranty. The rest of the contract stays on foot. And we'll talk about damages and how this calculation and things work at a later stage. But the key thing is, if it's breach of warranty, the contract stays on foot, which means both sides are obliged to keep performing. Okay, now, sometimes you can have not one term that can be construed one way or the other as either a condition or a warranty, depending on the scale of the breach. Sometimes you can have multiple breaches of a non-essential term, a term which is clearly going to be a warranty, but multiple breaches of that term can actually, and this is the phrase there, go to the root of the contract itself. So if you have situations where you have to provide some form of service, and you hire somebody to do this particular service. So say I'm paying Carissa an amount every 2 weeks to go and take my t-shirts and sell them at one of the market events. All right, and I put in the contract, it's got to be 9 o'clock, you've got to be there at that particular market. If you do this for 10 times, and you're there at 9 o'clock each time, then you have one where you get there at 10 o'clock, then you're carrying on being there at 9. That's going to be construed as a breach of warranty. Still going to be able to get some dollars, in theory, because you were late for that one time. Won't be very much dollars, but I can't terminate. If, however, the main or dominant reason for me wanting you to be there at 9 o'clock was because a certain group of people, say these cyclists, came in at that particular time who really loved my patterns, and you were there not at 9 o'clock, and I suffered as a result, and then that got repeated a few more times. Each of those, in theory, is a breach of warranty because it's a minor term, but the collection of them can add up to be considered to be a breach of a condition because it goes to the root of the contract itself. And the right to terminate. If I can prove that multiple breaches go to the heart of the matter, that because each individual one is a warranty, and both sides accept that, coming late once isn't going to be much of a problem at all. Coming late every single time is going to go to the heart of the problem. And when we're looking at this, it's tricky to see all ends. It's one of those things that the courts have got to make this determination of whether or not a particular breach goes to the heart of the contract. It's a question of fact. Courts will look at the objective intention of the parties in terms of how they would have come together and what has happened up to that point and what will likely happen into the future. So just make note that because this is a question of fact, it's not subject to appeal. So if the trial judge, something like this goes to trial, and they're trying to determine whether or not something is an absolutely fundamental breach that goes to the heart of this contract, they will do that by looking at the objective intention of the parties when they came together to form it, and looking at all of the factors involving this, again, me with Carissa with these t-shirts, then making this determination based on what is the likely outcome for these things, looking at all of the facts. It's a question of fact, not a question of law. Now, there is one particular type of term which by default is always an intermediate term. What type of terms are they? They're terms as to time. The time of performance. You don't talk about it, very, very clearly map out how important the relevance of performance is and how important it is in the minds of the parties and the instruments. By default, it will be an innominate term. And there's a couple of cases here. The facts are essentially similar, Union Eagle and Re-Ronham. So I'll talk about Re-Ronham. That is a conveyancing case, and it was on the Gold Coast, and it involved commercial property, large commercial property, for sale on the Gold Coast, and the place of settlement was on the Gold Coast. The solicitors were in Brisbane, and the transfer system was down that day. They had a lot of dramas that morning. And to compound this, there was a furious electrical storm. And so they had to go somewhere in central Brisbane to do this thing manually, then take the documents to the Gold Coast, and it was an outrageous traffic jam as a result of the crazy weather. And it was specified that settlement would occur at a certain point in the afternoon, I think 5 p.m. in the afternoon. And so what happened? The vendors, I think it was in that case, arrived at 7 minutes past 5. And the purchaser said, nah, too late. And this went all the way to the Court of Appeal. And what did the Court of Appeal say? They said, nah, too late. Why? Because the parties, when they came together, specified very, very clearly that that particular point in time was essential. And they could look at other factors here too. Remember what happens at 5 o'clock on a Friday afternoon? If there's an error, something needs to be fixed, you need to call someone. You can't do it. And this is went to the Court of Appeal in 1998. It was a few years before that, but basically before cell phones. You couldn't get hold of people. And they looked at all of these things for determining it. But the key thing was in the instrument itself. It had said performance of this is to be held absolutely strict. And so that's one of those situations where it was kind of tough luck. They did arrive late. It was agreed to be an essential term, looking at all of the facts and the objective intention of the parties. And as such, the deal got cut off. And look, you guys are probably aware that if you're late with conveyancing matters, it often the other side does get the right to terminate, which they chose to use in this case. And other situations, you can have what's called a pre-estimation damages clause. And again, we'll talk about that at a later date. So just make note also that this rule about time not being of the essence, time being an intermediate or an innominate term, is actually enshrined in the default rules. These are the default rules, in this case for the sale of goods, and in the Property Law Act. The default rules for contracts is time, if it's not of the essence, it's not agreed by the parties as being particularly important, it will be an intermediate term. It'll be a reasonable length of time. And a minor breach will give rise to damages, and a major breach will give rise both to damages and the right to terminate. Okay, and in some situations though, when looking at particular types of contracts, you can look at time and the requirements for time, as they did in Re-Ronan, and they look at the type of contract, and they look at the facts surrounding them. And in some situation, things are going to be very logical. An example of that is the carriage of goods from boats. If you have to get your cargo to the boat at a certain time because it's going to leave, if you're 5 minutes late, that's not going to be a minor breach. That's going to be a major breach, because the consequences that flow from that are going to be massive. You have to take the next boat. And so sometimes when you're analysing these situations, the facts themselves will tend to look, essentially be one way or the other in terms of time being of a great deal of importance or not. Okay, now there's one sort of exception, sort of sub-rule to this, and that's that you can actually, in contract law, where you have not specified that time is an essential component, you can make it so. You can actually, as a contract is being performed, actually go and give notice to the other side that time up until this point may not have been of the essence. Now we are going to make it of the essence. You can do that in situations where it hasn't been specified. And there's some rules there. That, again, this was expressed by the High Court a while ago now in the 60s. And so you you have to appreciate this is only going to apply in situations where the other side's already behind. They've done some sort of default, they're already in breach of some obligations. And that can be, as I'll talk about in the second half of this lecture, that can be because it appears that they are unable or unwilling to complete the contract according to the time given. When you are giving this notice, a really important rule, not just for this, but from other areas of contract too, is that you can't sit and rely on your rights at common law if you couldn't do it either. You have to prove that you are what's called ready, willing, and able to perform in order to give the other side notice to make time of the essence. The courts also look at how reasonable this is. It's one thing to say, time is now of the essence. It's quite a different thing to say, time is now of the essence. You must perform this contract in the next 25 minutes. That's clearly not reasonable. And so it's one thing to make time of the essence, but the courts are only going to take this into account where you have not only said you're going to make it of the essence, you've mapped out a reasonable time and mapped out the consequences to the other side of doing that, which again can be, we're going to terminate at this point in time, or we are going to change some aspect of our own performance. And that'll... No, not assuming that they're all, remember, they have to already be in breach in that situation. They have to be in default or behind at some situation. Either it looks like they're behind, or they have to actually be behind. But it still has to be reasonable. You still have to actually be able to objectively, and this is again from the perspective of an impartial third party, say that where we haven't specified this, it's now important that we are to specify this time in order to give some efficacy to this contract itself. Otherwise, it's particularly in situations where people are tardy, where the contract hasn't specified that time is essential or important, you can essentially say to them, can you please hurry up? This is essentially what this doctrine of notice is about, the rule in tropical trade is. It's basically giving them more structure in terms of how and where the times that they've been up to. Because with all of these things, when the parties come together, it's quite common for parties to not talk upon a time, or to say there is a particular date, but to not really stipulate what the consequences of going over that are. And we've seen this in our own lives, when people have gone and done and agreed to do things, and you've had a certain day, and that date's gone by. Payment of things, payments for goods. These are the sort of things where it's not uncommon. When you sell things to people, you're waiting on payment, they may be a day or two late. In most situations, it's okay. Giving them notice of this, hey, you are behind at this situation, we want to actually enshrine a particular date at that point in time, and to have failure mapped out. Okay, so if you have reached a point in time where the other side has committed a breach, you're the innocent party. And as such, you get some rights. You get some rights. Now, as I'd mentioned earlier, the rights that you get depend on the type of term that's breached. So if it's a breach of a contractual condition, you get the right to damages, sue for damages, and the right to terminate. If it's a breach of a contractual warranty, you only get the right to get damages. And if it's a serious breach of an innominate term or intermediate term, you get the right to do either or. You get the right to do both sue for damages as well as terminate. Okay, there's a couple of other rules that come from this now, because this right to terminate, you can choose to forgo that right. Where the other side has committed a breach, you've got this option. This option doesn't stay open forever. you have the option to either carry on with the contract. You can do this. Of course you can. Hey, you've arrived too late for this particular, we'll say the conveyance earlier. Yes, you've arrived 15 minutes late. We're going to carry on, still do the conveyance. We're going to sue you for damages as a result of this breach. In other words, we're going to treat this breach of a condition, this breach of an essential term, just as a breach of warranty, get some money from you, but carry on doing what we said we were going to do. And a key thing to note there is that if you do carry on, you've got a duty to carry on doing what you said you were going to do. It's part of contract law. Because it's a breach of contract, you're always going to be able to get dollars from the other side. But you can choose to forgo your right to terminate for a breach of a contractual condition or a major breach of an intermediate term. Because things get tricky when both sides are in breach. Now, this is where the situation starts to break down. Because if we think about it, this right to terminate, it just arises automatically through operation of law. Hey, this is a contractual condition, the other side's breached it. We don't need a court to tell us this. We get the right to terminate immediately. In common law, these common law rules of contract, they're really big on self-help remedies. They don't want people to go to court. Going to court's expensive, it's time-consuming, it's stressful, costs the taxpayer. We want people to be able to solve their own problems themselves. The difficulty arises when I think that Opal is in breach of a contractual condition, and she thinks that she's only in breach of a contractual warranty. Why is that a problem? Well, because if I elect to terminate, and I do it essentially wrongfully, because I was wrong about how I've construed that particular term. Maybe, for example, it was very important to me personally, but objectively, it wasn't important. Then I've got a problem. Because assuming that I've terminated, and I'm no longer performing what I said I was going to do, I'm in breach. And so Opal then gets the right to terminate the contract for anything that I haven't done that was essential to the contract. If I'm undertaking breaches of contractual conditions or major breaches of innominate terms. And that is why these rules are given to you guys with a great deal of caution, because while they are set out to be self-help rules, they're given to people in business and essentially for parties and individuals in their private lives to sort out arrangements between themselves. But if you get it wrong, the consequences can be dire. If I was wrong about how that contract was construed, Opal then can turn around, sue me, and I'm going to be the one at fault, and I'm going to be liable to pay her. Does that make sense? That makes sense? It's really about this inability to construe stuff ahead of time. Now, and again, I'll end this recording shortly and move on to the repudiation, because this idea of characterizing terms as one or the other can be done very carefully through the instrument. Remember that a contract is, as best as possible, as a written instrument, something where you are trying to enshrine the mutual intention of the parties. And so if the parties come together and say, this particular term is going to be a condition, major term, and both parties agree to that, well, the court's going to place great weight on that particular fact. But it's not the be-all and end-all. Sometimes parties, particularly more powerful parties, can say everything is a condition, and they're the ones construing this. Whereas in reality, when the courts look at the underlying facts, really none of those things really matter. And there are some statutory rules as well. And the main one being Section 14, subsection 3 of the Sale of Goods Act, which is in contracts for the sale of goods. I haven't got it on the slides actually, but I'll tell you it now. When you are purchasing goods and title has passed, so in other words, where the other side has accepted the goods, inspected them, or had the opportunity to inspect them, by default, if you don't map this out anywhere in your contract, once you've accepted the goods, titles has passed, and you can only treat breaches of a condition like a breach of warranty. Why is that important? It means you can't send the stuff back. Once you've been given the goods, by default, again, all of the rules in the Sale of Goods Act can be overridden through express agreement of the parties. Once you have received goods, Queensland Sale of Goods Act 1896, section 14, subsection 3, says once you've received goods and accepted them, title passes, and from that point forward, you can only treat a breach of condition like a breach of warranty, because you can't, essentially it just means you can't send the stuff back. You can still sue to get damages, and don't get me wrong, damages could be large. We'll talk about the calculation for that in a few weeks' time. But you can't give the stuff back. Title is passed. 14 subsection 3. 14. And like everything in the Sale of Goods Act, those rules can be contracted out of. It's the big distinction between the Sale of Goods Act and the Australian Consumer Law. The consumer guarantees in the Australian Consumer Law cannot be contracted out of. Pretty much everything in the Sale of Goods can be. Because really, it was designed for merchants, by merchants, for merchants. That's really what the Sale of Goods is about. Whereas the Australian Consumer Law is designed to protect the little guy. It's designed to protect consumers. Okay. I'm going to transition that.